Welcome back to Law News Network, everybody. This is Jesse Weber. Thanks for joining us. I apologize. We are taking you out of that police interview of Louis Toledo. I will play that in its entirety, but in the meantime, I do have a special segment that I need to talk to you about. It's very important. We are talking about Harvey Weinstein, specifically the Weinstein Company, the board. Can they be sued? Can they be sued, and how? How's that possible, and is it in conjunction with what happened to Mr. Weinstein? This is a whole big discussion because now there's whole reports that Harvey Weinstein's board can be sued, and there's been a lot of questions about his contract and what to make of it, a lot of interesting questions about legal issues, but there seems to be confusion. So now we need to set the record straight, and to help me set the record straight, I'm here with entertainment and sports attorney Seth Berenzweig. Seth, it's great to have you back on to talk about this case.
Thanks for having me.
So let's start from the beginning. We know that the board of directors, we saw a report, they are possibly liable. They're possibly open to a lawsuit, I would assume, from the shareholders. Can you explain a little bit more about this?
Absolutely. So the general rule is that the board of directors of a company, or whether it be a closely held company or a more broadly held company, usually enjoy a lot of protections from personal exposure and liability for the actions of employees. It's unusual for them to face some kind of a lawsuit either directly from the other shareholders or derivatively by the shareholders through the company. But the game changer in this case is information that came out just a couple of days ago that Harvey Weinstein had an employment contract with the company that literally seems to have provided some kind of a price menu for an increased gradation of fees and penalties for every time that he potentially sexually harassed someone. So, for example, the contract provides that he would pay the company liquidated damages of $250,000 for the first such instance, $500,000 for the second such instance, $750,000 for the third, and $1 million, and so on.
Wow.
So in an employment contract that I've never seen before, and I've been handling, among other areas, employment cases for over 25 years. Never seen anything like this.
Thank goodness.
Thank goodness. This now elevates this case out of the normal situation, and now you have a bottom line where the board of directors appears to have known potential predatory conduct. That puts them on the line for breach of a fiduciary duty, and that's just a game changer.
So let's see if we get this straight. Because he had this in his contract, and I want to talk about a little bit about that because there has been a back and forth. We did our own analysis here on the Law News Network. Our very own Allura Nanos broke it down in an article. Because there's a contract that talks about his sexual harassment and what would happen if he's implicated in that, that seems to show that the board of directors, knew about his issue at the time they drafted his contract. So in a way, that's a clear indication of evidence that they knew about it. Am I correct?
That's exactly right. And what it does is it eviscerates some of the very traditional time-honored defenses that a board would ordinarily apply in a situation that is not as kooky as what we have here. So, for example, there are times where the board of directors can apply something called the business judgment rule that says that unless they take an action or apply a judgment that is clearly outside of the normal and reasonable scope, that their actions and their deliberations ordinarily will not be second-guessed by a court. It would be incredible for the business judgment rule to apply here because you have such a unique background where the board actually has knowledge of this kind of a predatory behavior. The other thing that comes to mind also is some of the more traditional employment law-based doctrines like intervening acts or conduct outside the scope of employment. That applies in situations where someone's behavior, which could be an assault or criminal behavior, is something that's outside the realm of foreseeability. Well, how's the board going to say that when they literally apply a pricing menu for sexual harassment in its own employment contract?
Do you have to prove that these allegations are true before shareholders would have a claim against the directors?
Well, they wouldn't have to. They would have to be able to present allegations in a lawsuit that, if proven, demonstrate that they have a viable legal claim against the board of directors. So it's a little bit of a lower threshold out of the starting gate. But to cross the finish line, yes, they have to show by a preponderance of the evidence that this is demonstrated, and I think that there's going to be so much evidence against the company here. There are at least, from the reports that I've seen, at least 40 women over the course of decades that have come out publicly. And not only is that telling with regard to the numbers, but they really all are telling very similar stories. And not to get too graphic, but you really have these situations of Harvey Weinstein allegedly pulling them into a corner, asking them up to a hotel room, asking for a massage, very lurid. And there really is an underlying common denominator of allegations and circumstances. So this is a real problem. There's also news that the company is looking to sell itself, but if they're straddled with so many legal issues within and outside of the company, they're really going to be caught in a major problem here.
Yeah, and let's not forget, it's not only that he sexually harassed these women, he threatened them, and that's really where it gets to a whole different level. You know, he threatened their careers and made it's as cliche as you get about someone in a high-powered position doing this, but it's horrifying to hear. So we seem to understand that they have a cause of action and how they can do it. But what is the theory that these shareholders are suing? Because of all these allegations that came forth, he was fired. Did it diminish the value of the company? Did it hurt? It's not a public company, it's a private, but did it hurt the value of the company? What's their theory? What is their damages based upon these allegations?
Sure, that's a great question. I think that the core claim would be a breach of fiduciary duty and a violation of the standard of care. The allegations would likely assert that these board members breached their fiduciary duty by, on their watch, permitting this kind of predatory behavior that was essentially endorsed with foreseeability on an underlying employment contract, and that as a result of that, endorsers are pulling out, clients and other projects are pulling out quite a lot over the last couple of weeks, aside from the diminishment of reputational the presence, of course, of reputational harm, which would be, I would presume, very substantial. So what would happen here is you would likely see, I believe, something that would ultimately lead to what's being called and what has long been known as a derivative lawsuit. In a derivative lawsuit, as long as the shareholders go through exhausting their internal formalities by, for example, issuing a letter to the board, which is just a rubber stamp formality, saying that they intend to bring a lawsuit to preserve the assets and the value of the company, then they can subsequently, on behalf of and through the company, file a derivative action. I believe that this is a company that is authorized and filed under the laws of Delaware. So you could have in a court in Delaware a derivative litigation action that would be teed up against the board of directors.
And let's settle this. We'll get back to their claim in a minute, but let's go back a bit. There's as you said before, this liquidated damages clause, the thing in Harvey Weinstein's contract that would basically show that the board of directors knew about his proclivities. And the idea is, and I would like to settle this with you right now, when TMZ first reported it, they said that this contract allows Harvey Weinstein to sexually harass women. We came out, showed that from our own analysis that that's not exactly true. It shows that they would have to Harvey Weinstein would have to reimburse the company in the event of sexual harassment claims. I want to make sure I understand this properly. If they are sued, if the board of directors is sued by the shareholders, A, does Harvey Weinstein have to reimburse them at all? And B, let's make sure we understand what this clause means in general. Does this mean if anybody at the company was sued for sexual harassment, he would have had to reimburse them? I think we just need some clarity about what this contract means for Harvey Weinstein's liability in terms of the Weinstein Company.
Sure. So the employment contract appears to have been executed in 2015. That indemnification and reimbursement would probably be prospective. TMZ has reported on this contract, and although it hasn't been easy for the public to get their hands on a full copy of the contract, no one from the Weinstein board has disputed TMZ's report. So what it means for Mr. Weinstein is that for every action at a minimum for the past 3 years under the contract, he would have to reimburse the company for any full amount of any settlement or judgments, plus the what I call the menu of fines that layers in as a result of the first, second, third instance, so forth. So from Harvey Weinstein's perspective, he's on the hook for at least the last 3 years. It's unclear whether it would go back further than that. However, as far as the company is concerned, I think that they would be on the hook potentially for they'd be on the hook at least for the statute of limitations time frame for a derivative action, but all of the evidence that would go back for all of those years would probably come into play within some degree or window of time, because it just shows knowledge. How does the company say that it had no clue that around at least 40 people have been sexually harassed by this man? And in light of these contract provisions, really a big problem. The other footnote that I would drop is, you are correct, TMZ has characterized this as giving Harvey Weinstein permission to commit sexual assaults. I think TMZ, on the facts, did a really good job on the reporting. I think that their summary of the contract impact is slightly overstated. I don't think that their conclusion on that is quite accurate. I think that what they're basically doing is they're just kind of turning a blind eye and a blind ear to it and just saying, you'll just pay for it down the road. I don't think that they permitted him to do it, and they would come in and just say that this is their HR policy. So TMZ overstated it a little bit, but clearly this is one of the most reprehensible employment contracts that we might have seen in a very long time.
Yeah, and as I said, I don't want to see any more like these. I just want to make sure I understand this, though. So even if like 40 women have come forward and said that he sexually harassed them, they wouldn't necessarily, and I know we're getting off topic a little bit, but I will get back to this, the board of directors liability.
Sure.
The company wouldn't necessarily be liable for sexual harassment claims if he sexually harassed an actress or somebody that wasn't affiliated with the Weinstein Company or employed by the Weinstein Company, correct? I mean, in the sense that, wouldn't those sexual harassment claims only be for people that were employed by the Weinstein Company or were somehow working for them?
Yes, there needs to be some kind of a business nexus, and I would say that it could be an employment. I would say that they could even be a consultant. But I agree with you. I think that there has to be some kind of a business nexus, some kind of a privy of contract, which can be loosely defined. It can be as a W-2 employee, as a 1099 independent contractor or consultant. Yes, I think that I would agree with you 100%. If they have some kind of a contractual privity with the company, then the company, the allegations will probably come down, would allege that the company had essentially actual, if not at least constructive knowledge that this guy was a predator, and that it failed to exercise any kind of reasonable standard of care to prevent what should have been seen down the road as something that would ultimately lead to some kind of, at a minimum, sexual harassment, and unfortunately perhaps rape. And then in some states, such as in New York, for those kinds of aggravated sexual assault issues, there's no statute of limitations on that. So from a civil perspective, you have a can of worms, and even from a criminal standpoint, there is a whole new door opening, at least in the state of New York, with regard to criminal exposure for Mr. Weinstein as well.
Now, there's been arguments that the shareholders really won't sue, and they won't sue for two reasons. A, it's not in their financial interest to do so. As you talked about earlier, if they don't file suit, why not just sell the company, and it might be more profitable for them to do that without any impending lawsuits. Or the other thing is, it's such a closely knit organization. We don't know the actual framework and the structure of the Weinstein Company, but we're assuming that if it is so closely knit, how could the shareholders themselves not have known about Mr. Weinstein? Either of those arguments, are they plausible for why maybe we won't see lawsuits by the shareholders against the directors?
Sure. I think that what you've done is you've very accurately painted the backdrop of what's going on in the situation. And ironically, when you talk about the issue of which shareholders knew or should have known, let's keep in mind Harvey Weinstein is still a shareholder. He and his brother Rob own approximately 42% of the company. Apparently, he and Rob have been estranged for several years, but the shareholders include, ironically, Mr. Weinstein, because he was terminated, but he wasn't separated as a shareholder. You've also pointed out a business reality in the backdrop. So what could happen is the other shareholders of this closely held company could come into the board and say, look, you have a problem. There's a huge liability here. And if you don't expeditiously trigger a sale of the company and a resignation of all of the current board of directors that are sitting to oversee the affairs of the company, then we're going to use that as leverage to trigger a Delaware derivative case against all of you. So I think you're right. Is there liability that sits there? Yes, but it wouldn't necessarily just lead to litigation. It could lead to everybody coming in and saying, let's just close this book and put the chapter behind us, because this whole thing, probably in everybody's view, is a nightmare.
It is a nightmare, and I'm sure they're wondering what to do right now. My question to you is, and I'm gonna push you. I have a question. If you were representing the Weinstein Company, what would you advise them to do? I don't know if it's the most glamorous position right now, but if you were having to defend them, what would you advise them to do with all of this news coming forward, with these possibly impending shareholder lawsuits? What would you advise the board to do?
Wow, that is a fair but tough question.
Those are the kind I like to ask, by the way, so just be prepared.
No, that's more than fair. Well, ordinarily, when we handle a case like this, we tell the company to immediately conduct an investigation and review. But when you're talking about allegedly the biggest predator in North America, and you should have known 28 years ago what was going on, that kind of gets thrown out the window. They were supposed to conduct the review, but then 2 days later they terminated him anyway. I think that what I would tell the company is that they need to execute all negotiations with due haste to do everything that they can to completely separate themselves from Harvey Weinstein. I think that they handled it okay, only with respect to triggering a decision within about 48 hours of when the temperature really got hot to force him out, even though there were some covenants in the employment agreement that arguably restricted them from doing that. But I would tell them, look, you have to completely trigger a separation from Harvey. You have to enter into a global settlement agreement to terminate his participating interest as an equity owner of the company, and then I think that what you need to do is you need to trigger a sale and you need to resign. When counsel represents a corporation that is alleged to have done very bad deeds with clear mismanagement and violation of a standard of care by the board, the duty is to the company. And if the board's going to execute any reasonable degree of prudence and meeting its fiduciary duty, they need to get the hell out. They need to sell the company. They need to take an inventory of liabilities. So at the end of the day, I would say to them, inventory the liabilities, batten down the hatches, get ready to sell the company, and then you all need to be ready to resign and get out of town, because that's the only thing that could save the company and any little shred of integrity and goodwill that's dangling from it after this debacle.
And I imagine all the impending projects that they had, the ones that were in development, will have to be caught up by other production companies, and that's going to maybe be a war to get those projects, because as much as terrible as this is, the Weinstein Company did put on some good productions, and you can imagine studios and different production companies wanting to get a hold of those. I would imagine trying to get those assets.
Absolutely, that's the harm. I was listening to MSNBC this morning on the way into work, and one of their anchors is a woman that is one of the lead anchors on the show. She had a book deal that was with the company, and she has made it very clear to them that she's pulling out, and until they clean up house, she's gone. She's one of a litany of people that have really jumped off the ship.
Yeah, and I think I just read Channing Tatum had a production with them. He pulled out. It's a really, really terrible situation, what's happened with Mr. Weinstein and the horror that he's caused on so many lives, and everybody in the industry is being affected. But as we've talked about here, as we talked about with you, Seth, it seems to be for the good, because hopefully some good can come from it, and there can be changes that are made. And hopefully we never see contracts like this again with employment contracts. So again, Seth Berenzweig, entertainment and sports attorney, thank you so much for coming on to talk about this case, and we're definitely going to love to have you on to talk about this case as more as entertainment stories as they come forward.
You bet. My pleasure.
Thank you.
Bye-bye.
So there you heard it. The Harvey Weinstein issue, very complicated, but it seems that board of directors could be facing some liability from the shareholders. But then again, as Seth said, it's not so simple, because the shareholders, it's a tightly lit organization. They have a financial stake. Mr. Weinstein's still a shareholder. It might not be so simple, but it's possible. The Weinstein Company will be sold, and we'll have to see what the aftermath of that would be. In the meantime, we are